Good morning or good afternoon, ladies and gentlemen. It is a great pleasure for me that I can talk a little bit to you about certain developments in German legal or legislative developments which have taken in the last few months, actually since a year already, and are continuing. And why is this important for you? All of you, I think, will be interested in how patent litigation in Europe is taking place. And first remark to make in so far is that we of course don't have a European patent in a real sense at the moment. We have a European Patent Office at Munich, as you know, with some branches in other countries of the European Union. We have a so-called European patent, which you can get out of these institutions of the European Patent Organization, namely the EPO with its various branches. But what comes out at the end of the day is not a centrally enforceable European patent. Rather, out of this organization come out national patents in certain so-called designated countries. That means nowadays you have the chance, the possibility, as somebody who is interested in obtaining patent protection for a product, a method how to manufacture, related to telecommunication, to chemistry, whatsoever. You have two ways to get national patents in Europe. One possibility, you file national patent applications, for example, supported by priority, namely according to Paris Convention of earlier national or regional applications in other parts of the world. And you file those national patent applications at the national patent offices of the respective European country. Like in United Kingdom, no longer belonging to the European Union, as you know, in Switzerland, in Germany, and you name it. The other possibility to obtain national patents in Europe, however, is that you file a European patent application at the European Patent Office in Munich, which later on, at the time of grant, explodes into a bundle of national patents in those countries you wish have to patent protection, you wish to get patent protection in, and you have another kind of national patents. Those national patents, whether obtained via national patent offices or whether obtained through the European Patent Organization, can only be enforced at the moment in national courts in those respective European countries where the patent exists. For example, if you have parallel patents in, let's say, United Kingdom, France, Germany, you have to go, if you wish in parallel to enforce them, into the courts of Britain, France, and Germany with the respective national patent obtained in one of the aforementioned manners. There might come at some point of time, and now we go into the crystal ball observing process, a so-called unitary patent, which you would then also get from the European Patent Organization, covering the whole European Union, but for example no longer covering Britain, United Kingdom, because United Kingdom recently, as you know, has left via Brexit the European Union already. That unitary patent, if this project, let's call it Unified Patent Court or UPC project, becomes true, is realized, could be enforced at a unified patent court, which would be central. That means you would not have to go to national courts in any of the EU countries anymore. You would go to the Unified Patent Court, the seat of which, however, still being undecided. It would be a central division with a main seat in Paris. Yes, that we know. it would be another seat in Munich. Yes, that we know. But the third seat, which was provided for or branch, namely intended to be responsible for chemical, biotech, pharma inventions, to be in London, is at the moment in the air, as the whole project is in the air. Because what has happened is, and this is part of German patent legislation, I would just like to talk about, what the moment of the project, what the fate of the project, UPC project at the moment is, that it is still necessary that Germany ratifies as one of the obligatory or compulsory countries to be taken in care of by ratification during the whole UPC process. German Parliament has passed an implementing law which makes sure, or will make sure, if the UPC project will be realized, that the ratification document, which has passed German Parliament already, would be signed by the President of the Federal Republic of Germany and then deposited. But unfortunately, or fortunately, depends on which side of the picture of the discussion concerning UPC, its sense and nonsense, respectively, you are. The President has not signed yet, and a constitutional complaint has been filed at the German Federal Constitutional Court, which is the highest legislative authority, if you wish so, in Germany, and the case is pending there. Some people think that the German Federal Constitutional Court will pass, nevertheless, the law will allow, in other words, the federal president to sign the ratification document, but other people think it might still take 3, 4, 5 years before it comes into force. So for the moment, we don't know. There is no uniform or one, let's say, a single European patent which you could enforce at one court, the Unified Patent Court in Europe. Will that change? We don't know. Maybe never. Maybe in a couple of months. Maybe in a couple of years. So for the moment, you have to live with the national patents I have talked about. Namely, national patents obtained either nationally from a national patent office, like Germany or other countries, and national patents obtained via the EPO route. If you as a patentee would have the possibility to now look at your, let's say, parallel European patents you might have got in United Kingdom, in Netherlands, in Germany, and wheresoever, you would have a possibility, of course, presently to go against an alleged infringer who infringes all over Europe, to go via forum shopping choice to all countries at the same time, and then you would not be doing and conducting forum shopping. But nobody has so deep pockets that he or she really would do this. The patentees will go to a patent and patentee-friendly country. They will choose one first, and then possibly go to other countries. And here some statistics might help, from which you see why Germany is so important and why I would like to talk about the ongoing legislational efforts in Germany with regard to changing, modifying, improving the present patent litigation provisions. You could go to Netherlands, of course, but in Netherlands you have the problem. It's absolutely great courts, great lawyers, great patent attorneys, patentee-friendly, I would generally say. Problem, you don't close such a big part of the European economy that somebody who also in an unauthorized manner uses the respective technology all over Europe would feel deeply impressed and maybe even thrilled to look for a Europe-wide settlement. So you go to the next best country, and that is Germany. And this is the reason why the first reason is market size. And again, market size, because Germany covers about 40% of the overall GDP of the European Union. And if somebody would, by an injunctional relief, by an injunctional judgment, be forced as an unauthorized user to stop all activities in Germany for the future, then that defendant, that alleged infringer is practically forced into settlement covering the whole of Europe. And actually, 80, maybe even 85% of all patent litigation filed in any European country is filed at German courts. 80 to 85%, at least in the years 2018, 2019. Only in 5% of all these cases, in parallel to the patent litigation in Germany, or after the end of it, out of parallel patents in other European countries, patent litigation will take place. In other words, in a nutshell, in 95% of all cases, the German litigation decides the case for effect of all Europe. And that is the reason why people go to Germany and have a close look there. And there is another reason nowadays, and the reason is well known to most of you, it's the famous or infamous injunction gap. How is the legal situation in Germany in patent litigation at the moment? And not to change for the foreseeable future, at least not in a sense that this injunction gap would fully disappear. But we will see what Germany is trying to soften it, to smoothen the procedure. Germany has a bifurcation in a compulsory form. That means if somebody files a patent suit for injunctional relief, as well as damages usually, in any of the German specialized patent litigation courts, that court will not listen to, completely handle, and will not decide on patent invalidity. That means a defendant who is, for example, sued at a court in Düsseldorf, a very famous patent litigation court in Germany, will argue at that court that he does not infringe in the usual manner, but when he raises invalidity arguments, the only thing he can do is to ask the court to wait until a parallel invalidation complaint the defendant in patent litigation will have filed at the German Federal Patent Court in Munich is decided. So, if you wish to defend in Germany against invalidity, against a patent, and you wish to argue invalidity, you cannot do it at the litigation court. You must go by a counter-attack against the validity of the patent at the German Federal Patent Court. What is the problem now? Well, the problem is the Federal Patent Court is very competent, but is very slow. That means the procedures there until a first instance decision on validity will take about 2 to 3 years, and in the patent litigation case you will get an injunctional relief already, a decision within 1 year, which is immediately enforceable against bond. So what can happen, and very often happens nowadays, is that the court where patent litigation is being handled, let's say at Düsseldorf, issues an injunctional relief decision, and then the patentee goes to the defendant in patent litigation and say, listen, you have requested for staying the litigation procedure, but we have seen it has not been stayed. Only in about 10 to 15% a court like Düsseldorf would stay the procedure. So I bring you out of the market, I stop you from all infringing activities for the next 1 to 2 years until the invalidation case will have been decided, and you, in all friendliness, will not survive this, so to say. So I offer you a deal. You give me money and you pay for my not executing the injunctional order. This is the normal use, or some people say abuse, of the presently existing injunction gap in Germany. Now, what is the German legislator doing against this? We have pending in Parliament, actually, in the Bundestag, the first chamber, a second Patent Modernization Act. So the German Patent Modernization Act, I leave the second away, is pending, and it has been brought into Parliament already in October, November last year. The first reading in the Parliament has taken place in January. Now the expert hearings in various legal committees, etc., in the Parliament are going on. Then the case will go back to the German Federal Ministry of Justice, and they will possibly take into consideration the various results of the expert hearings and what has been done in parliamentary discussion up to then, up to about end of March. Will revise the law to a certain extent or will not do it, we don't know, this German Patent Modernization Act, and then it will go back to Parliament for the second and third reading. That second and third reading can, for technical reasons, not take place anymore before end of April, and will take place then either in May or in first half of June or never. Why not never? Because in September of this year we have a general election in Germany, a new parliament will come, all legislative actions still pending by then will die and will have to be taken up again by the Federal Ministry of Justice and the new parliament, etc. afterwards. And if that happens, we will not have a German Patent Modernization Act coming into force earlier than in 2022. But there are efforts, and I think very promising efforts and hopes, that it will still happen within the next few months. That means the law would then come into force probably already in July of this year. What is the purpose of the law? The purpose of the law is to narrow the injunction gap, which nowadays is only due to the fact, as you have seen, that the litigation courts issues an injunctional relief within 1 year, and the Federal Patent Court, deciding on validity, will need another 1 to 2 years after that decision of the Patent Litigation Court, creating this very long period of 1 to 2 years where the patentee can stop because of the injunctional relief as granted by the Patent Litigation Court in his hands, will use for, let's say, rather one-sided settlement negotiations with the defendant in litigation. Namely, the defendant does not wish to get out of the market, so he will pay, and it is kind of an accumulated royalty and a damage from the past altogether. How can this injunction gap, what is the intention of the law of the German Patent Modernization Act, to be closed? It is as follows. First, the Federal Patent Court will in future, after having received a invalidation action complaint by the defendant in patent litigation, or also by any third party. You can file patent invalidation requests at German Federal Patent Court whenever you like, even by a strawman, even as a lawyer or patent attorney not liking invalid patents. You don't need any moral reasons for that, no legitimate interest or so. Everybody is legitimated to do this. And now they will introduce by that law that the Federal Patent Court, within 6 months after having received the invalidation action, will have to issue a qualified opinion on the potential or probable outcome of the patent invalidation procedure. That qualified opinion will be given to the Patent Litigation Court, so that 6 months after the filing of the invalidation action, the litigation court will know about the opinion of the Federal Patent Court, the invalidation court, as to the prospects of the pending invalidation action against the patent. That will enable the litigation court, before trial in the litigation procedure, 12 months about after filing earliest of the litigation complaint, to consider this expert opinion like qualified opinion of the invalidation court, and then can have a better basis for staying the procedure or not. So this is one aim of the law, to accelerate the invalidation procedure. The second one is, at the moment, Article 139 of German Patent Act brings about a automatic injunctional relief on behalf of a patentee. And that means there is no eBay-like situation like in the United States at the moment, they could consider the litigation courts whether there are interests of the defendant which are justified enough not to issue an injunction should be considered, but practically it is not done, and particularly also third parties' interests are not considered. So, Article 139 is intended to be changed by the German Patent Modernization Act in such a sense that when issuing an injunctional relief, when deciding on the issuance of an injunctional relief, you have to consider the well-balanced interests, not only of the patentee, but also of the defendant in patent litigation and of third parties. Why is that so important? Imagine there is a patent on a chip, on a computer chip, and that computer chip is made by some chip manufacturer, and the chip manufacturer is attacked because of patent infringement. The chip is of rather low, let's assume, monetary value, but it is necessary to be used in a car at the end of a supply chain. The car is a very expensive, maybe luxury car. And at that time, if the injunction would be granted to the plaintiff out of this computer chip protecting patent, the production of the car would be stopped at the end of the day. So big financial risks would arise for the car manufacturer. And this can influence negatively, whether in telecommunication, in car industry, in all parts of industry, heavily commercial considerations and the ways in which supply chains might be used. So the aim is that in future injunctional relief will not be granted if well-justified interests of the patentee, well-justified interests of the defendant and of third parties compared with the interests of the patentee will lead to the result that it would be against, I would say, equity considerations, good faith considerations to issue an injunction. So this is the one thing. The one thing is the second thing. One thing is acceleration of invalidation proceedings. Second is the eBay situation, the proportionality which will be introduced into German injunctional decision procedures. The third one, which is still on the way, and we don't know this in this German Patent Modernization Act, whether it will be successful, is that one would make invalidation actions against German patents already possible, both national patents and EPO-obtained German patents, during the time when still an opposition could be raised against the patent in question, and or, same thing, if it would still be possible for the defendant in patent litigation to join a pending opposition procedure which has been started by a third party. At the moment, German law, according to Article 81 of our Patent Act, prohibits this, and as long as that is prohibited, defendants against attacks out of early technology patents where opposition could still be raised or joining an opposition procedure would still be possible, would not benefit from this acceleration process in the invalidation procedure if in future they also could not file invalidation requests already during the aforementioned period. This will change if that addition to the law, which is at the moment not yet in the pending draft at Parliament, but will probably be introduced soon, does not provide for a provision which allows a defendant in patent litigation to file invalidation action immediately after having been sued because of patent litigation. What is the fate of the law to be expected? I gave you the timeline. It will, from my personal perspective, become true. It will get into force in this form which I have just tried to describe somewhere in this summer, June or July, and then we will have a lot more proportionality in German patent litigation. It will not mean that it will not be advantageous also in future to sue for patent litigation against unauthorized users, but it will at least remove the blackmailing opportunity which at the moment exists because of the injunction gap, which is somehow embedded into the law and particularly the consequences in practice when these laws are applied by the German courts. That was it all in short. Keep your eyes open if you have more questions concerning the developments in Germany. Please do not hesitate to contact me through the organizers of today's event or by sending a personal email to you, not to you, by you to me. Send me an email, I will answer your questions. I will do this as long as it's a general question, cost-free of course. I think it is my obligation to do so if I could not explain in my brief speech here today the situation of German patent legislation sufficiently clear. Thank you so much.